Adam asked, what's your stance on doing work for nonprofits? I have no problem doing work for nonprofits, for a profit. Many nonprofits think that you can write off the work you do for them as a tax credit. They are mistaken. In 1985, the law changed regarding doing work for nonprofits. After 1985, the only type of tax credit an artist receives for doing work for a nonprofit is for the supplies involved. Nothing else. That means that nonprofits have to pay the going market rate for any type of design, illustration, or artwork. This change in the tax law had many ramifications. It used to be that artists could donate their work to museums in exchange for tax credits. Museums in return would then have a plethora of artwork to show to the public. Since 1985, museums have found themselves in the uncomfortable position of having to actually pay artists going rates for contemporary artwork. Nonprofits also found out that any work done for them by photographers, painters, designers, illustrators, any sort of creative professional would have to be paid for. Nonprofits have found that it is possible to do projects for a limited budget if they provide full creative freedom to the artist. Many awards given to creative professionals are for projects that have been done for nonprofits where they've had full creative freedom. And that's where the business trade-off is. I would not consider doing work for a nonprofit unless I had creative freedom, or if I was being paid the market rate. I hope that helps. I had finished taping, put the camera, lights, and tripod away when I spoke to my friend and legal counsel, Daniel Abraham. And Daniel reminded me of a key point that I forgot to mention. Nonprofit refers to an entity's tax status. An entity's tax status has no bearing on how much you should be charging them. They pay the same amount you or I do for services, whether that's mailing a letter or their utility bill. From a practical business standpoint, there's no reason that you should be charging less to a nonprofit entity than to a regular entity. Thanks for the reminder, Daniel.
Disclaimer. Mark Monlux's advice is self-indulgent pontification which may or may not cover the general principles of law in response to issues of concern to the illustration community. Nothing in these articles should be construed to be a substitute for advice of counsel regarding the specific facts and circumstances of an individual case. Laws and their interpretation differ from jurisdiction to jurisdiction. Legal advice addressing a specific situation should be sought from an attorney duly licensed in the appropriate jurisdiction.